want to get into a case I know you're keenly interested in, and that, of course, is the Bryan Kohberger murder case that just today in a courtroom in Boise, Idaho, pretrial motions were underway. Both sides there inside kind of hashing out some of these logistical concerns before this trial gets underway later this summer in August here. So we did learn quite a bit about how this is all going to go. I guess for journalists, it's important for us to see this, watch it live as it happens once it does get to trial. And the trial, which is scheduled to begin August the 11th, will be live streamed. That's according to Judge Stephen Hippler. He ruled that today during this hearing. So Hippler also agreeing to a request from prosecutors to shut down the live stream when the surviving roommates are testifying. So that's a key kind of detail there as well. Now, the judge also said during the hearing, jurors will consider whether to impose the death penalty or life in prison without parole if Kohberger, of course, is found guilty. Obviously, you need a conviction to even discuss the penalty phase. But this trial is expected to last several months here. So in the meantime, we do have some of our reporters standing by there in downtown Boise who was following this today. But let's just get a sense of what transpired in court. Let's listen to just a little bit of the proceedings. This was a virtual hearing today. Let's watch.
Certainly counsel and the defendant proceeding have the right to be present, but when the questionnaires are administered, but I suggested to you that perhaps your time is better spent in reviewing the questionnaires than watching people fill them out. The process will be such that as we bring groups in to fill those out, those will immediately be scanned and then provided to counsel on a shared drive. And so I guess I wanted to get your feedback on whether I suspect this is a all for one or not proposition.
Thank you, Your Honor. My understanding is we have both agreed that there's no need for counsel from either side to be present during that stage. We'll focus on the tasks at hand.
Okay, very well. Does that accord, Ms. Taylor?
It is, Your Honor.
All right, very well. So as I indicated, you'll be given access via shared drive. You can do two things. One, you could save those over to a copy over to a drive in which you can make edits, or you can print and make hand edits, or you can just keep track by notebook and juror number. If you want to do the printed version, you'll need to bring your own printer and supplies in order to print those off from your war rooms. The plan will be to take the universe of jurors who are summoned and then scramble them randomly and assign them what we call a scramble number, 1 through 10,000. And then we will bring them in to fill out the questionnaires beginning with 1. So that the questionnaires that you receive first will be the jurors most likely to be in the line of fire, so to speak. Because once we have enough jurors, we'll stop. So that's the plan. Anybody have any concern with that?
No, sir.
No concerns, thank you.
Technically, under the rules, you are entitled to watch the scramble process, which literally involves the jury commissioner hitting a button. I don't know if any of you want to be there for that.
No, thank you.
We'll waive our presence for
All
that,
right.
Your Honor.
Very well. I do want to stress the security and confidentiality of the juror questionnaires, as I'm sure you're aware, pursuant to Criminal Rule 23. Those are extraordinarily confidential. The copies that you receive will be, we'll maintain a copy, obviously, for appellate purposes, but the copies you receive will be returned. The defendants, they're supposed to be essentially attorney's eyes only. I'm fine if you both agree to allow an investigator to see, so that they can be doing, whatever online investigation they feel appropriate as you go along doing that. In terms of the defendant, his access has to be with attorneys present. In other words, he can't have a copy or whatever to go back with him when he's not with you.
That makes sense, but I have one question for the court. In addition to our investigators, we have 3 that are working on the case. We would request our paralegals be allowed to assist us. Just with the magnitude of the task, we'd like to have the assistance of our paralegals in organizing and reviewing.
Okay, so I wanted to just kind of give you a sense, a taste of this in court today there in Boise. But you see there Bryan Kohberger in the white dress shirt and the tie with his team of attorneys, of course, the man accused of killing 4 University of Idaho students. He was back in court today. There you just see him. Well, Fox News multimedia reporter Kennedy Hayes, she right now live in Boise, Idaho with the latest on what happened in the courtroom. She joins me. Kennedy, good to see you here. Get us up to speed. What do we need to know about what happened in court today?
Good to see you as well. Well, that's right. Kohberger's attorneys actually say they received a tip that points to an alternative suspect, and they submitted some mailed documents to support that claim. But the judge said today that he still has questions.
It seemed to me much of what you had put in there was fairly potentially fairly objectionable in terms of admissibility.
Travel. Judge Hippler is giving the defense until next month to provide more details. Kohberger sat quietly in court today wearing a white shirt and tie. He's facing 4 counts of first-degree murder and 1 count of burglary, accused of stabbing 4 University of Idaho students in their off-campus home more than 2 years ago. The judge also ruled on how much of the trial will be shown publicly, allowing a live stream but banning close-ups and juror faces. 12 jurors and 8 alternates will be seated. The jury will not be sequestered during the trial, but will be during deliberations. The judge approved the use of a model of the crime scene during the trial. Prosecutors apologized after referring to it as a, quote, dollhouse, a term the defense said was insensitive and potentially misleading. A judge told both sides to use the term model house going forward. And we also learned today that during the trial, 2 seats will be reserved for the 2 surviving roommates. That is, if they choose to attend. The trial is slated to begin in August and could last several months. If convicted, Kohberger is facing the death penalty. Andrew.
Kennedy, just a few questions. Were any family members or friends of the victims inside this hearing today? Do we know?
I did not see any family members of the victims that were identifiable, at least, but I can say that the courtroom wasn't that empty. If I were to estimate, I would say it was about 35–40% full capacity-wise.
Yeah, and Kenny, I always kind of ask you, apart from the media that is on scene, to cover a story like this, what about your everyday locals, your residents of Boise, people who have come out to see what's going on? Is that element a part of this story just yet?
Yeah, well, I can tell you I've been covering this trial for several months, and in terms of pre-trial hearings so far, this one was a little bit more crowded with locals just in the courtroom, but we know the next pre-trial hearing is scheduled for June 18th. That one, though, is likely to be closed, but definitely once trial starts August 11th, there may be more crowds out here.
All right, Kennedy Hayes there live for us in Boise. Kennedy, good to see you. Great reporting. We'll talk soon. All right, in the meantime here, we do have a live shot as well in Boise over the airport there. We do want to bring in some of this legal analysis as well in our friend Nicole DeBoard, who's joining me. And Nicole, thanks for being with us here. You have been so instrumental in helping us make sense of this story. I got to start with this, though. The defense bringing this into this pretrial motion today, what they brought in, we'll get to it in just a moment, spurred the very need for another date for a pretrial motion. They call it an alternative perpetrator. I mean, if you want to talk about a wrench thrown into this, they think someone else did it. Do they have to say who? And in this next hearing, what is that going to look like here? I was shocked by this. They have, in their minds, a completely different suspect.
They do, or they at least have evidence that they believe points to an additional suspect or a new suspect, someone other than their client. And of course, this is the only time to raise that kind of evidence. You've got to get that in front of the judge to have rulings about whether or not this will be admissible evidence. And as you heard from some of the judge's comments, this may not be something the judge feels meets the necessary requirements to actually come in a court. And so what we're going to hear as this case moves forward and they come back to court for this hearing is whether or not this material that the defense believes they found pointing to an alternative suspect is something that can even be presented during the trial.
Yeah, I just want to amend what I said there. The judge is asking defense attorneys for additional evidence to support the allegations of an alternative perpetrator. To your point, they say they have evidence to suggest someone else might have done this other than their client, Bryan Kohberger here. I mean, would you characterize this as a Hail Mary in this trial here, do you think?
On the one hand, certainly that's what the prosecution would say. On the other hand, you know, this is the time. If the defense believes they have even a shred of evidence that might point to somebody else having committed the crime for which their client is on trial, they really must get that evidence in front of the jury if there's any way to do it.
So, Nicole, I mean, even the judge, though, didn't seem like he was ready to entertain this. I mean, you saw the look on his face there in that soundbite from Kennedy Hayes. He said this: "It seemed to me much of what you had put in there was potentially fairly objectionable in terms of admissibility here." So it even seemed to take the judge by surprise.
You know, it's new, right? After all of these extraordinarily thorough and detailed hearings about evidence and objections and ways that things will be presented in court, we have what is really a new issue that this judge is having to consider. You know, it's exhausting work to have to address all of these issues as they arise. And what he's seen so far, at least according to those comments from the defense, is really telling him that he doesn't have enough information to decide whether or not this kind of evidence would even be admissible in front of the jury, and he wants to know more.
So like I said, this spurned yet another pretrial motion, that date set for May the 23rd. This was supposed to be it. I mean, this was supposed to be the last one until this trial is going to start August the 11th. It'll be Monday through Friday. It's expected to last several weeks, and it's going to be live streamed. Did you anticipate that?
You know, we've been wondering whether or not the court would choose to allow for this to be live streamed. Certainly having this kind of a trial go blow by blow, if you will, you know, with cameras in the courtroom can sometimes impact the way evidence is presented. So I'm not entirely surprised, but certainly there was a question in my mind as to whether or not the judge would allow it.
You know, Nicole, I do want to talk about whenever the jury will be sat, when jury selection begins. The question that, and it was brought up there in court today, whether or not the jury will have to be sequestered. And that is a really kind of Herculean task for kind of any court clerk and courtroom to make sure that goes off without a hitch. It's a difficult job. Do you anticipate that will be necessary? Should this trial have a sequestered jury because of how high profile it is?
Another great question. I mean, we need to know, I think, a little bit more about what kind of confidence the judge will have that the jurors who are ultimately selected to hear this case can keep themselves insulated from outside influences as they hear it. It can be a very difficult thing to ask for either side, quite frankly, for jurors who are hearing a case that could go for this long to not have access to their homes, to their families, to their daily lives, even in the evenings. And so, sequestering a jury is a very big ask that both sides need to take incredibly seriously. And the court will also be considering whether or not there are alternatives to make sure that these jurors can make decisions based on what's heard in court and nothing else.
Obviously for journalists and the public, the fact that it is going to be live streamed, just for the public record, that's good news here. But I want to issue this caveat that came out in court today. The judge also agreed to a request from prosecutors to shut down the live stream when the two surviving roommates are testifying. We're talking about some of the star witnesses going on in the Diddy case in New York and their testimony. Would you describe these two surviving roommates, not witnesses, but roommates, as star witnesses for the prosecution? Would you put it that way or no? I mean, their testimony could be quite crucial, right?
I really think they are star witnesses. They are as close as we can get to people who have direct information about what happened that night. And even if maybe they didn't see all the things that they wish that they could have gone back to have seen, really the pieces of information, the sounds that they heard, where they were, what they were doing, all of these things will really paint a picture for the jury who has to decide whether or not Kohberger is the person responsible for this crime.
Nicole, I just want to go back to this alternative perpetrator theory offered by the defense here. Do they even need a name or someone, or do they just need shreds of evidence to make it admissible here? I mean, what's the burden on them to make this credible?
It has to be something that is reliable enough to get in front of the jury, right? Not just sending the jury on sort of an irrelevant rabbit trail, if you will. It can't be based on mere speculation. It has to be evidence that has some foundation in a credible source that points to someone else. So, it can't be hearsay upon hearsay. It can't be evidence that is lacking in some kind of other foundation that helps us understand that it may have some indicia of reliability. So what we expect, I think, next week when we hear further information about why the defense thinks that this is reliable evidence, the judge is going to have enough to decide that it's relevant to this particular case and does indeed potentially, at least in some small way, point to a possible additional suspect or different suspect.
Yeah, and I just want to also amend this too, because we did have reporting from Kennedy Hayes. I had asked you about jury sequestration. The jury will not be sequestered during the trial, but during deliberations. Lastly, in these pretrial motions, Nicole, that there are winners and losers. It's either the defense or the prosecution as we get closer to trial. Were there winners and losers today, or did each side get something that they wanted?
It seemed to me that both sides got something that they wanted, and I think that we all got a lot of information about how this trial will proceed from a practical standpoint, what it's going to look like in terms of scheduling, what it's going to look like in terms of how the court plans to run things, and what the court thinks is still missing in terms of decisions that it has to make moving forward so that this trial can go off on time.
All right. Nicole DeBoard, as always, can't thank you enough. I think we'll be speaking a lot later this summer. Thanks so much. Have a good night.
Thanks for having me.